Myself, Dr. Anjali Bansal Goyal. I am Assistant Professor, Punjab University, Chandigarh. The topic of my presentation is Equality 1, Classification, Non-discrimination and Non-arbitrariness. Article 14 of the Constitution states that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Reasonable classification, non-discrimination and anti-arbitrariness approach all are attributes of Article 14. There are two phrases in Article 14, equality before law and equal protection of laws. The phrase equality before law finds place in almost all written constitutions that guarantee fundamental rights. It is English in origin. It is a familiar feature of what Dicey called the rule of law. Rule of law means that no man is above the law and that every person, whatever be his rank or condition, is subjected to the ordinary law of the land and is amenable to the jurisdiction of the ordinary tribunals. Thus, equality before law signifies that among equals, the law should be equal and should be equally administered, that like should be treated alike, absence of any special privileges for any particular individual. The phrase equal protection of laws is based on Section 1 of the 14th Amendment of the Constitution of the United States of America, adopted on July 28, 1868, which runs as, "Nor shall any state deny to any person within its jurisdiction the equal protection of laws." This phrase is interpreted to mean subjection of equal laws applying to all in the same circumstances. All persons have the right to equal treatment in similar circumstances, both in the privileges conferred and in the liabilities imposed by laws. It is known to be positive in content. Thus, the phrase equal protection of laws lays down the rule that like should be treated alike and not that unlike should be treated alike. There are different dimensions of Article 14. The first dimension is that Article 14 permits reasonable classification. It is an integral part of Article 14. The Supreme Court has emphasized on this dimension in Chiranjit Lal Chaudhary versus Union of India. An ordinance, namely Sholapur Spinning and Weaving Company Emergency Provisions Ordinance 1950, was promulgated with the purpose to take over the management and administration of the Sholapur Spinning and Weaving Company Limited, as the industry concerned was closed down due to disputes between the management and the employees. The court observed that the law would be constitutional even if it applied to one person or one class of person if there was sufficient basis or reasons for it. In Ram Krishan Dalmia versus Justice S.R. Tandolkar, Inquiry Commission was appointed under the Commission of Inquiry Act 1952 against one of the Dalmia concerns on the ground of mismanagement in the said concern, apprehending considerable loss to the investing public. It was challenged on the ground that Act of 1952 gave wide and unregulated discretion to the government, resulting in the denial of equality. The discretion conferred by the Act was not unguided as laid down by the Supreme Court, as the Act had clearly laid down the policy, that is, to inquire into matters of public importance. The court upheld the action against the petitioner and laid down that while Article 14 forbade class legislation, it did not forbid reasonable classification for the purposes of legislation. Principles for determining reasonable classification as laid down in Dalmia's case and further elaborated in Re Special Courts Bill 1978. First, the basic principle of right to equality is that all persons similarly circumstanced should be treated alike, both in privileges conferred and liabilities imposed. The state is vested with power to determine who should be regarded as a class for purposes of legislation and in relation to a law enacted on a particular subject by the process of classification. Classification means segregation in classes which had a systematic relation usually found in common properties and a rational basis of characteristics it's postulated. Test for reasonable classification. The classification must have some intelligible differentia, that is, some basis which distinguishes persons or things that are grouped together from others left out of the group. The differentia must have a nexus with the object sought to be achieved by the statute in question. Single individual may be treated as a class by himself on account of some reasons applicable to him and not applicable to others. The court will always presume in favor of constitutionality of an enactment, and the burden is upon the person who alleges violation of constitutional norms to prove any such violation. For application of this principle of constitutionality, the court may take into consideration matters of common knowledge, the history of the times, and may assume every state of facts which can be conceived existing at the time of legislation. Where classification is not based on reasonable grounds, then this presumption of constitutionality cannot be carried to the extent of always holding that there must be some undisclosed reasons for subjecting certain individuals to discriminating legislation. Members of Parliament as well as State Legislative Assembly are the representatives of the people. They understand their need and make laws in order to find solution to their problems. Legislature is free to identify the degree of harm and may limit its restrictions to those cases where the need is deemed to be the clearest. Thus, it could recognize the degree of harm, but that classification should never be arbitrary, artificial, or evasive. The statute itself cannot be condemned as discriminatory if it has clear and definite legislative policy. Discretionary power would not necessarily mean discriminatory powers. It cannot be assumed that the authority would always act in an arbitrary manner if discretion is conferred upon it by law. A practical assessment of the operation of the law in a particular circumstance is necessary. Then, basis of reasonable classification. Classification to be reasonable must be founded on some intelligible differentia which distinguishes persons or things that are grouped together from those left out of the group. There may be different bases of classification referable to different considerations like geographical basis, historical basis, nature of business, nature of persons, nature of offences, educational qualifications, sex, financial status, etc. The first instance is classification on the basis of sex. Section 497 of Indian Penal Code 1860 defines the offence of adultery. It provides that it is only the adulterer who shall be punished for the offence, and the woman, the adulteress, would not be punished even as an abettor. Section 198 subsection 2 of Criminal Procedure Code 1974 gives the right to prosecute the adulterer to the husband of the adulteress and not to the wife of the adulterer. The constitutional validity of this provision was challenged in the case of V. Revati versus Union of India. The philosophy underlying appears to be that as between the husband and the wife, social goodwill would be promoted by permitting them to make up or break up the matrimonial tie rather than to drag each other to the criminal court. They can either condone the offence in a spirit of forgive and forget and live together, or separate by approaching matrimonial court and snapping the matrimonial tie by securing divorce. There could be classification on the basis of financial status also. The Right to Education Act 2009 has been passed by the Parliament, which provides for free and compulsory education to children. Section 12, subsection 1, clause C of this Act provides for admission to class 1 to the extent of 25% of the strength of the class of the children belonging to weaker section and disadvantaged group, and provide free and compulsory elementary education to them till its completion. This provision was challenged in Society for Unaided Peace School of Rajasthan versus Union of India. The Supreme Court held it to be a valid classification. Thus, classification between children belonging to economically weaker section of the society and others is valid. Classification could be on the basis of nature of offence also. The constitutional validity of the Uttar Pradesh Gangsters and Anti-Social Activities Prevention Act 1986 was challenged in Dharmendra Kirthal versus State of UP, as it provides that the accused under the Act shall be tried by special court. The court held that such kind of organized crimes has become epidemic in the society and has to be dealt with an iron hand. Thus, classification between an accused who faces trial in other courts and the accused in the special courts is valid. Where classification is not valid, it has been struck down by the Supreme Court. One of the instances of such kind is the Ministry of Finance, Government of India took the view that a visually impaired person cannot be equated with hearing impaired person, since persons who are deaf and dumb are not physically dependent on others for commuting from one place to another. Hence, they are not entitled to double rate of transport allowance. This decision was challenged in Deaf Employees Welfare Association versus Union of India. It was held that under the Disabilities Act, the persons with disabilities are entitled to the benefits of all the schemes and benefits provided by the government, and there cannot be further discrimination between a person with disability of blindness and a person with disability of hearing impairment. Such discrimination has not been envisaged under the Disabilities Act. The differentia sought to be canvassed by the Ministry of Finance has no rational relation to the object sought to be achieved by the Disabilities Act, which envisages to give equal opportunities, protection and rights to the persons with disabilities. Hence, this decision was struck down by the Supreme Court. In National Legal Services Authority versus Union of India, the Supreme Court held that gender identity refers to each person's deeply felt internal and individual experience of gender, which may or may not correspond with the sex assigned at birth, including the personal sense of the body, which may involve a freely chosen modification of bodily appearance or functions by medical, surgical or other means and mannerisms. Gender identity, therefore, refers to an individual's self-identification as a man, woman, transgender or other identified category. Article 14 does not restrict the word person and its application only to male or female, as said by the Supreme Court in National Legal Services Authority's case. Transgender persons who are neither male or female fall within the expression person and hence entitled entitled to legal protection of laws in all spheres of state activity, including employment, healthcare, education, as well as equal civil and citizenship rights as enjoyed by any other citizen of this country. The second dimension of Article 14 is that Article 14 strikes at arbitrariness. Equality is antithetic to arbitrariness. This new approach was developed by the Supreme Court in E.P. Roepa versus State of Tamil Nadu. It was observed that equality is a dynamic concept with many aspects and dimensions, and it cannot be cribbed, cabined and confined within traditional limits. The court reiterated the same opinion in Menka Gandhi versus Union of India, where it is observed that Article 14 strikes at arbitrariness in state action and ensures fairness and equality of treatment. This new approach has been consistently applied by the courts in determining the true scope of the equalizing principle. Though there cannot be any exact definition of arbitrariness, but a basic and obvious test to apply in such cases is to see whether there is any visible principle emerging from the impugned action which satisfies the test of reasonableness. There are three aspects of this dimension. The first aspect is that doctrine of justice, equity, fairness and reasonableness should be applied in the state action. This doctrine implies that every action of the state and its agencies or instrumentalities to give or confer benefit must be founded on a sound, transparent and well-defined policy which shall be made known to the public by publication in the official gazette and other recognized modes of publicity, and such policy must be implemented and executed by adopting a non-discriminatory and non-arbitrary method irrespective of the class or category of persons proposed to be benefited by the policy. Instances of reasonableness and anti-arbitrariness in state action. Principle of reasonableness implies that the state and its agencies or instrumentalities cannot give largesse to any person according to the sweet will and whims of the political entities and officers of the state. Principles of governance have to be tested on the touchstone of justice, equity and fair play. Radio spectrum in 2G band was deliberately kept underpriced and allocated on first come first served basis, spectrum thus falling into hands of some unscrupulous parties who had no genuine desire of providing 2G telecom services, and spectrum was used by them to earn huge profits by its indirect sale via sale of equity. In Centre for Public Interest Litigation versus Union of India, the Supreme Court held that manifestly unwise economic decision of a government department resulting in misallocation or misuse of scarce resource was held to be arbitrary. In the similar manner, malafide termination of senior superintendent of police whose eligibility, suitability and credibility has never been questioned after change in government was challenged in J. Jayalalitha versus State of Karnataka. The Supreme Court held that if the reasons for taking the decisions are not based on values but to achieve popular accolade, the decision cannot be allowed to operate. The state should not change its stand merely because the other political party has come into power. Political agenda of an individual or a political party should not be subversive of rule of law. Moreover, if any legislative provision is arbitrary, then that provision is struck down by the Supreme Court, as Article 14 is against arbitrariness. In one of such instances, policy was devised by the Union and the states facing Maoist insurgency, whereby tribal youth appointed as special protection officers are placed in grave danger by virtue of the fact that they are employed in counter-insurgency activities against the Naxalites in Chhattisgarh. In Nandini Sundar versus State of Chhattisgarh, the Supreme Court held that subjecting such youngsters to the same levels of dangers as members of the regular force who have better educational backgrounds, receive better training, and because of better educational backgrounds possess a better capacity to benefit from training that is appropriate from the duties to be performed in counter-insurgency activities, would be to treat unequal as equals. Moreover, inasmuch as such youngsters with such low educational qualifications and the consequent scholastic inabilities to benefit from appropriate training can also not be expected to be effective in engaging in counter-insurgency activities. Thus, the policy of employing such youngsters as SPOs engaged in counter-insurgency activities is irrational, arbitrary, and capricious. In another instance, the constitutional validity of Bombay Police Amendment Act of 2005 was challenged in State of Maharashtra versus Indian Hotel and Restaurants Association, whereby Section 33 Clause A I prohibits holding of a performance of dance of any kind or type in any eating house, permit room, or beer bar having facilities below the rank of 3-star. The distinction, the foundation of which is classes of the establishment and classes or kind of persons who frequent the establishment and those who own the establishment, cannot be supported under the constitutional philosophy so clearly stated in the preamble of the Constitution of India and the individual articles prohibiting discrimination on the basis of caste, color, creed, religion, or gender. Thus, once the prima facie proof of the arbitrary classification of the establishments under Section 33A and 33B was given, it was the duty of the state to justify the reasonableness of the classification. Then, this doctrine of reasonability is applied by the courts in various landmark judgment. For example, the Government of India 2011 Hajj policy required a private operator or travel agent to have minimum office area of 250 square feet as one of the eligibility conditions for registration for ferrying pilgrims for Hajj. Requirement of minimum office area for private tour operator was challenged in Union of India versus Rafiq Sheikh Bikham. The Supreme Court held that this is reasonable as some of the private tour operators, after getting registration and allocation of seats, instead of carrying the pilgrims themselves, sold the seats to other private tour operators. The ministry decided to take action against such unscrupulous private tour operators. A genuine private tour operator should be having an office with a reasonable area. Its purpose is to protect the interest of the pilgrim. The Juvenile Justice, Care and Protection of Children Act 2000 provides age of understanding as 18 years. Keeping in view the involvement of large number of juveniles in commission of crimes, it was challenged in Salil Bali versus Union of India. The Juvenile Justice, Care and Protection Act 2000 is in tune with the provision of the Constitution as held by the Supreme Court, and it was further held that one of the other consideration which weighed with the legislation in fixing the age of understanding at 18 years is on account of the scientific data that indicates that the brain continues to develop and the growth of a child continues till he reaches at least the age of 18 years, and that it is at that point of time that he can be held fully responsible for his action. The third instance of doctrine of reasonability is that the institution of adoption is not recognized under Muslim law, keeping in view the restriction imposed on them by personal law, whether they could make adoption under Juvenile Justice Act 2000 or not. This issue was discussed by the Supreme Court in Shabnam Hashmi versus Union of India, where the Supreme Court held that adoption by Muslims is permitted under Juvenile Justice Act 2000. They can adopt a child with full rights as natural parents under the provisions of Section 41 of the above mentioned Act. It was further observed that personal laws cannot dictate the operation of provisions of an enabling statute like Juvenile Justice Act 2000 and cannot come in the way of person who chooses to adopt a child under this act. It is a secular law and a small step in reaching the goal of uniform civil code under Article 44 of the Constitution. The third dimension of Article 14 is that it provides positive and not negative equality. It implies that any action or order contrary to law does not confer any benefit upon any person for similar treatment. Equality cannot be invoked to perpetuate an illegal order. Instances of positive equality. In Commissioner of Police, New Delhi versus Meher Singh, the appointments were to be made in police force by screening committee. Rejected persons challenged their rejection on the ground of earlier appointments of certain persons of doubtful integrity being made by the committee. The Supreme Court rejected their contention and held if the screening committee, which is constituted to carry out the object of the comprehensive policy to ensure that people with doubtful background do not enter the police force, deviates from the policy, makes exception and allows entry of undesirable persons, it is undoubtedly guilty of committing an act of grave disservice to the police force. But we cannot allow that illegality to be perpetuated by allowing the respondents to rely on such cases. In another instance, in Oswal Agro Mills Limited versus Hindustan Petroleum Corporation Limited, Oswal Group proposed construction of the residential commercial complex in the vicinity of the refineries and other storage tanks of Hindustan Petroleum Corporation Limited. HPCL opposed this proposal and filed petition against the same, which was upheld by the High Court. Oswal Group pleaded that there are already buildings in the vicinity. Construction of high-rise buildings within 800 meters of the respondents' refineries, which is located in an industrial area with many other industries, is a threat to the security and safety of the respondent. The Supreme Court held that the high-rise buildings would overlook the storage tanks containing inflammable substances and may serve as a launching ground for any external object towards it by terrorists and the kind. Merely because there were already other buildings in the vicinity, it cannot be a ground for allowing the appellant to do the same. The last dimension of Article 14 is that rules of natural justice is implicit in it. Natural justice is a part of law which relates to the administration of justice. Rule of natural justice are indeed great assurances of justice and fairness. The underlying object of rules of natural justice is to ensure fundamental liberties and rights of subjects. Thus, they serve public interest. The adjudicatory process essentially has to be in consonance with the principles of natural justice, including the doctrine of audi alteram partem, hearing the parties, application of mind and recording of reasoned decisions are the basic elements of natural justice. In Manohar Manik Rao Anchule versus State of Maharashtra, the Supreme Court held that even the State Information Commission exercising powers under the provisions of the Right to Information Act 2005 is performing adjudicatory functions where two parties raise their respective issues to which the State Information Commission is expected to apply its mind and pass an order directing disclosure of the information asked for or declining the same. Conclusion. In the end, it is submitted that Article 14 ensures equality before law and strikes at arbitrary and discriminatory state action. If power conferred by the statute or any authority of the state is vagrant and unconfined and no standard or principles are laid down by the statute to guide and control the exercise of such power, the statute would be violative of the equality clause because it would permit arbitrary and capricious exercise of power, which is the antithesis of equality before law. Our constitution envisages a society governed by rule of law, absolute discretion, uncontrolled by guidelines which may permit denial of equality before law is antithesis of rule of law. The exercise of all administrative power vested in public authority must be structured with a system of controls informed by both relevance and reason. Relevance in relation to the object which it seeks to serve and reason in regard to the manner in which it attempts to do so. Thank you.